I have seen a paper recently that showed that in Ecuador, which was the first country to enshrine rights of nature in its constitution, what they've seen is that very slowly, as lawyers and judges are becoming more familiar with the concept, they're better to interpret it when there is a legal case being brought. And they're better able to side on the side of nature. Now, that's a very slow process. And I'm not saying it's the panacea, but it's certainly much more positive than what we've seen in the past.
Welcome to the Mongabay Newscast. I'm your co-host, Mike DiGirolamo.
And I'm your co-host, Rachel Donald.
Bring you weekly conversations with experts, authors, scientists, and activists working on the front lines of conservation, shining a light on some of the most pressing issues facing our planet and holding people in power to account. This podcast is edited on Gadigal land. Today's guest on the newscast is Viktoria Kahui, a researcher in environmental and ecological economics at the University of Otago in Dunedin in Aotearoa, New Zealand. Kahui speaks with co-host Rachel Donald about the concepts and the applications of rights of nature laws and legal personhood for ecosystems. Related, but somewhat different concepts that are being trialed or applied in nations across the globe for a variety of reasons, including, but not limited to, Indigenous reconciliation and trying to protect nature. Some of these laws, Kahui argues, don't stem biodiversity loss, and in this episode, she outlines why. While there is some agreement that this is the case, there is some global debate as to the flaws inherent in some of these laws, whether they contribute to meaningful change or distract from it. There is some criticism that imposing an anthropocentric legal framework created by Western colonizing nations on something as complex as nature commodifies it, in a sense, or can be overly vague, leaving open the possibility of harming the very people that these laws are intended to empower. Some critics suggest a new paradigm in which laws are considered within the context of nature, recognizing that humans are co-participants of nature needs to occur. Kahui comments on this debate and argues why she thinks these legal frameworks still deserve some consideration.
Viktoria, thank you so much for joining us on Mongabay's podcast. It's a real pleasure to have you on the show.
Thank you.
So, we're going to discuss legal personhood with regards to protecting nature and the rights of nature. And I thought that given that these are two phrases that are being thrown around quite a lot in a lot of policies, certainly activists are suggesting policies based on these things, but they are different. So let's begin here. What is the difference between legal personhood and the rights of nature?
So, rights of nature is a generic term that describes legal rights being accorded to natural units. In Ecuador, it's all of nature. In other cases, it's forests or designated rivers. So legal personhood is a very specific type of rights of nature in the sense that legal persons can be both human and non-human. So typically we think about non-human legal persons such as organizations or charitable trusts. So they're just really a subset of rights of nature, so to speak.
And why have people been suggesting this as a tool that can be used to combat our damaging and extractive relationship to nature?
Well, I think there's many reasons, and there seems to be a bit of a wave going through the world advocating rights of nature. It started very slowly, and there's only, in a recent research, we looked at 14 well-documented studies, but I think I just looked recently, and there's about over 400 or 500 rights of nature case studies now, mainly in South America. So it's definitely taking off. It's a very important topic. There is not much research showing whether it is actually effective in stemming biodiversity loss. I think it's simply a cry out driven by the fact that our standard tools that we have, our current governance systems simply don't work. Well, they work, but they're not good enough to stem the biodiversity loss. And I think rights of nature just comes in as one solution, one potential solution to tackle the biodiversity crisis.
And how could it be that in some of these cases, it doesn't look like it's stemming biodiversity loss? Because surely if you grant legal personhood to a river, for example, I know that and you'll be able to correct my pronunciation on this, but the Wangkrumi River in New Zealand was granted legal personhood. How could it be that protecting it under the same system under which people and companies are protected actually wouldn't have a positive knock-on effect?
I'm just saying simply we don't know yet, because we don't know. I actually think it's a fantastic tool and it has a lot of potential, but we don't know it in the sense that there's no hard science, because a lot of these legal personhoods don't have any defined ecological outcomes and there hasn't been any measurements in place. So we don't have ecological measurements saying what was the state of a river or forest beforehand and what is it afterwards, after the implementation of legal rights. So we can't really say whether it has been effective. But in saying that, clearly, common sense dictates once you start protecting a certain feature, there must be improvements. Now, there hasn't been really, so just to correct it, it's the Whanganui River in New Zealand. So,
Thank you.
And what we've seen now in New Zealand is that I don't think it's really seen as a conservation tool per se. It's more a reconciliation tool. So it's really a lot of the Maori indigenous, iwi, trying to reclaim some of the injustices that have been done during colonization. So it's not seen as a conservation tool. It's really a reconciliation tool with settlement, so to speak. And we've had Te Urewera, which is a forest that was in 2014 being declared its own legal person, followed by the Whanganui River in 2017. And most recently, Maunga Taranaki or Mount Taranaki. That's the most recent case.
When you say an Indigenous reconciliation tool, do you mean between the state and the Indigenous groups, or between the Indigenous groups and the land, or both?
Primarily between the Crown and the Indigenous people. So, for example, in the Whanganui River case, it was the case that, a lot of the land and adjacent to the river had been alienated from the Indigenous peoples, the iwi there, Whanganui iwi. And there's been grievances throughout decades, and a lot of the gravel abstraction and steamer services had led to the deterioration of the river. And the Maori of Whanganui iwi had long advocated for declaring the river its own legal person, which eventually came to interact in 2017.
Now, you've written really, really interesting in the article, which was in the conversation, which was why we reached out to speak to you about this. One of the things that you wrote was that just granting legal personhood may or may not be enough because it doesn't cover the questions of liability. So who is liable for what? Who can sue or take action on behalf of these now considered legal persons? Do you have cases of how that's playing out in New Zealand, like how granting legal personhood to these rivers and mountains is enabling the Indigenous community to then protect or act for these rivers and mountains?
Unfortunately, there's no precedent in New Zealand yet. But when we started on this research, and I started with the question that everyone has, can rights of nature lead to natural protection in the stem of biodiversity loss? But as I pointed out, it was very difficult to find any sort of data or scientific information on that. And we can't just say it does. But what we could do is just simply start and compare these case studies around the world and say, well, what is it they have in common? And what makes them different from each other? Maybe that gives us some cue as to what is important about them when you start thinking about implementing or granting rights of nature to any natural unit. And that's when we came across this very interesting, these two very interesting case studies, both in the US and in India, which were overturned due to liability issues. So, for example, in the US, the Lake Erie bill, what happened is Lake Erie was granted legal personhood. It had the right to exist and flourish. So, maybe not legal person, maybe it was just rights for nature, but I'll explain a little bit later what the difference is. But anyway, as soon as the bill was implemented, adjacent farmers straight away went to court and said, look, what does it mean to for the lake to have the right to flourish and exist and evolve, what are we liable for? What happens if we can't reduce our fertilizer runoff to zero? There will always be some fertilizer runoff. And what exactly does that mean in court? So this was overturned due to vague laws.
This was known as the Lake Erie Bill of Rights, and it was voted on in February 26 of 2019, and almost exactly 1 year later, it was struck down by a federal judge on February 27, 2020, ruling it as unconstitutional. It was also, I believe, the very first instance of an ecosystem being granted legal personhood in the United States.
And India, a very similar case, but there are differences. Liability here came more from actually the guardians themselves. So the state of Uttarakhand declared the Ganges River as its own living person. What that means is it's not just a legal person, but a living person. So any injury to the river is a bit like injury to a human person. And they assigned guardianship to the state of Uttarakhand. And the state immediately went to court, to the Supreme Court, after it was implemented, saying, well, hold on. What happens if someone drowns in the river? Do we have to pay liability to the victims of the family of the victims? What happens to when, the river is polluted downstream or upstream? So there's transboundary issues. And very quickly, the case was overturned. So in both cases, it was due to liability. That's one thing that we noticed. Now, we compare that to actually what went well. What kind of case study, what rights of nature stands out in a positive way. And that's when we actually realized that the Whanganui River in New Zealand is really a benchmark for many of the rights of nature case studies around the world. And it's because they are paid such precise attention to detail in the sense that who exactly are the guardians? What legal status do the guardians have? So the guardians themselves are like a charitable trust. What are they allowed to do and what aren't they? And who exactly is going to make the decisions? So all these questions were very detailed. A lot of attention was paid to detail when that was answered. So the Whanganui River really stands as a bit of a benchmark worldwide. While really the Ganges and the Lake Erie showed us that, they can be overturned if we don't pay attention to let's say, liability.
That's interesting. There's almost like a translation of the spiritual, natural, historic relationship between the earth and man. It's like it's having to be translated into this more atomized legalese, essentially, for these decisions to stand tall in a world in which the legal order essentially is the new natural order. So I can understand this. Essentially, I guess what I'm trying to say is I can understand why allowing a lake to flourish, that kind of language, is very, very difficult to translate legally into exactly what that means and who would be responsible for what. And I think another interesting point in that story, and I read about this, was that, it is another vulnerable group then that could possibly be impacted by this lake's right to flourish. Our farmers, certainly all around the world, are seeing a huge backlash at the moment to the very necessary production of our food. Whether or not it's done in the best way is obviously open to debate. And I stand on the camp that thinks we could be farming definitely in a better way. But nonetheless, it's the people on the ground that are still being impacted. This tension between man and earth and production and overproduction is coming into play. Whereas I suppose really what the embedding the rights of nature or granting legal personhood to a natural entity would certainly be about sort of stopping the most extractive layers of society, the bigger companies or even the states, from just being able to do as they want without sort of paying the compensatory price for the extraction.
I think that's exactly right. And I'm an economist. So when I teach my students at university about environmental problems, typically how we phrase it is something, a negative externality, right? So there's some industrial activity or agriculture that has an impact on a third party, so some sort of environmental effect. Now, the key there is that when we teach this in economics, we always look at the impact of the negative impact of another person, right? So you can only take legal action on behalf of other people who are affected by some sort of environmental degradation. Now, this rights of nature is really interesting because it flips that around. It actually allows you to take legal action on behalf of nature itself. So you could think about it, right? If even if no one is affected or no one is bothered by some pollution, it doesn't matter, right? It's saying, well, the case is that natural unit itself, the river, is polluted, and therefore we can take legal action on behalf of the river. And that's unique. That's different, right? And that's not something we've seen. And when you think about it in terms of property, it's usually when you think about property, we think about either no one owns anything, which is the worst case of scenarios. That's usually the sort of tragedy of the commons, right? And unowned natural resources usually very quickly degraded. Or maybe the state owns something. This is when we think about regulation or taxes. Or maybe private property, right? When we own, for example, tradable rights, or like fishing quota. But nature owning itself, its self-property, is unique. That's not something that has made it really into the economics domain. And that's why I was so drawn to this, because I've been thinking about this for, many, many years. I've been thinking, well, what is the solution? I've always had this gut feeling that it has to do something with property, right? We have to define who owns what. And the worst case is when no one owns anything. And that's, I think, what we see currently with our ecosystem services, right? I mean, who owns the ability of a wetland to filtrate water and provide clean water, right? You might own the land, but no one owns the ability of the wetland to do so. So what we see is, of course, even private landowners have a piece of land, may drain the wetland and put a hotel on it because it generates income. But of course, what we've lost is the wetland, and not to speak of all the other values that are attached to it, such as habitat and bird life and so on. But these sort of ecosystem services are simply unowned, i.e., we do have regulations, of course, but as I mentioned before, regulations don't seem to stem the tide of biodiversity loss by themselves. So we need something else, right? And we need something that works in the current system. So especially here in New Zealand, declaring the river its own person was a very face-saving activity, because it means neither the Crown loses out nor the indigenous people lose out, right? No one owns the river, it owns itself. And that's why it was politically feasible, right? It didn't cause too much upset or too many problems. And I think that was a very elegant solution to some of the problems that have been plaguing iwi and indigenous Maori here in New Zealand for a long time.
I agree with you. I think it's a very interesting proposal, and I'm certainly much more for it than I am for putting a price on ecosystem services and that absurd number that has just been put on the total price of the earth, which is something like 6-point-something trillion. I'm sure Mike will be able to correct me in the show notes about this.
Thanks for mentioning that, Rachel. It was $5,000 trillion for all ecosystems services based on natural asset companies. However, the U.S. Securities Exchange Commission withdrew that application earlier this year, so it never came to pass. But listeners, if you want to learn more about that subject, listen to Rachel's great conversation with Rebecca Adamson, published back in June.
As if you could put a price on life, as if we extracted all of that value and then nobody could survive. Well, that was the cost of the entire experiment of the only living planet in the solar system. It's just bizarre. And I think the other thing that's really excellent about this is, given the amount of action that we're seeing around the world that activists are taking at the moment, for example, breaking windows of banks or companies that are involved in extractive action, and essentially having no legal defense, because they are saying, we are doing this for the future survival of ourselves, future generations, and also for the protection of the earth. And there's nothing in the law, essentially, to say, yes, that's a valid response. Essentially, the law has said, no, you've damaged private property, and thus you will have to be punished for that accordingly.
There does exist an actual legal defense that allows people to use climate breakdown as a defense for their actions, but its application is extremely spotty. To Rachel's point here, in the UK, recently 5 Just Stop Oil activists were given lengthy, multiple-year prison sentences for planning to block the M5 motorway. Keep in mind, they hadn't yet done the act of blocking the road. They had a Zoom call to recruit volunteers. The judge specifically rejected the legal defenses, which are similar to what Rachel is talking about here. standing up to prevent ecocide or climate breakdown. Another way this legal argument is referred to is the climate necessity defense. And it is an actual thing, and it was accepted in a case for people who did block a highway in the United States in the District of Columbia in 2022. The defendants still ultimately received sentences. But in other cases in the US, this climate necessity defense has led to acquittals, and more so when the defendants' actions were targeting fossil fuel infrastructure. If you want to learn more about these issues from an activist's perspective, listen to my conversation with Clover Hogan published back in April.
Whereas if you can begin to grant a self-property to the earth, if you can begin to identify it as a being or parts of it as a being in and of themselves that can then be identified in a court of law, you give activists a legal defense then for their action, especially if their action are just sabotaging or damaging private property and not, damaging other sort of persons. And I suppose it would then grant an interesting case of well, how does the law begin to parse the hierarchy of what is or is not most important? Is a bank window more important than a river? And I think for me, it thrusts into attention the unfortunate truth that most of our economic system and our legal system was built to protect a small minority of people and built to grant rights to those people and rights over other people and rights over the living world in order to facilitate extraction. And so it kind of brings that to a tension point when we're essentially saying, well, you've got two legal persons here. You have a bank or a company, and you have a natural ecosystem without which we cannot live. Who does the law back in that case? And it brings forward all of these other problems that we've been alluding to throughout this conversation into the light at that point. It makes it very difficult to avoid having that conversation.
Absolutely. I think what you're just hitting at is by giving nature or natural units legal rights, you're actually giving nature agency, a voice around the table. And you're totally right. I mean, the interesting thing is, you can't just walk into a shop and break a window. You'll be liable immediately. But currently you can pollute or degrade ecosystems or rivers or natural units without often being accountable. Now, when I say that, you have to be a little bit careful. Like I said, we have regulations in places, at least in New Zealand, that try and stop this. But sometimes it feels more like a slap on the hand. And of course, we know it's not enough by itself. So it's really about giving agency its own rights, legal rights, its own standing in court. And you're right, it just gives it a voice. Now, how that voice plays out is very interesting too. That's another thing we looked at in our studies. We said, well, who are exactly the guardians when you look at the structure of these rights of nature case studies? At first, my first gut instinct was, we were just going to list them chronologically and see, which case comes first or second or third. But what we found is actually there's quite a difference in how these rights of nature case studies are designed legally. So, for example, in Ecuador and Bolivia, rights of nature was enshrined into their constitutions. That means every citizen has the right to stand and speak on behalf of nature and take legal action. Well, when you think about New Zealand or let's say even Australia, often they are very specific appointed guardians. So in the Whanganui River case, it's one person from the Crown, one person from the iwi. And they are usually supported by some sort of advisory board. And these advisory boards include stakeholders, like all stakeholders, recreational fishers, councils, Meridian Energy, that all have some input into the decision making. So it depends really also, that's probably also a big difference between rights of nature and legal personhood, in the sense then who exactly are the guardians and are they financed? Because people have their time is valuable. So if you're deciding to represent a river, your time has to be accounted for, and there has to be some money being paid. So there's all these questions that are addressed in various ways to some extent across these rights of nature case studies.
This is totally anecdotal, but along the same vein, one of the most successful community projects in the United Kingdom that hasn't been about the rights of nature or legal personhood of nature, but about a community that had been held back by a lack of investment. the success of this project that has managed to build the biggest wind turbine on British soil by themselves, that has managed to get, a lot more public facilities that they need and built a really strong relationship with the council. When they talk about their story, they say the same thing. Like, we were in this for the long haul. We had a long-term strategy. We set up a charitable trust. We ensured that enough money was coming in there to be able to finance us working for it for 10 years. And then we went out and we saw other pots of money, and we had to learn the system. We had to learn how the system worked in order to then play the system. And they are incredibly successful. This tiny, tiny community on the edge of Bristol that had been totally left behind, essentially, by public money and by public interest, they've radically overhauled where they live and their own quality of life. And I think this leads us nicely to essentially, some of the criticisms that this is facing, which is, in the words of Audre Lorde, can you tear down the master's house with the master's tools? There are people like Jessica Hutchings, who's an Indigenous food systems and Maori soil sovereignty expert, who says that using legal rights could perpetuate an old colonial system, that we shouldn't be trying to use this existing system in order to create a new one or in order to reform it, because it facilitates this continuing proprietorial relationship to nature. What would you say to that?
I would say, well, give us a better solution. So what else is there, right? Look, these are not simple questions. They're very complex questions. And overturning the current system, capitalist system, is going to lead to a lot of other problems that, I don't think that's just a viable option, right? We all depend on it, right? We work, we have an income, we have a legal system, we have a medical system. This is very much part and parcel of where humanity is going. So the question is now, how do we do this? How do we grow? And I'm a big advocate of economic growth and good living standards. And, I embrace technology. I think it's fantastic. I'm glad I live in this time and not 200-300 years ago when there wasn't any antibiotics around, right? This is, I think us as a human species have done fantastic. But in the process of doing so, we have left nature behind. And now the question is how do we actually bring nature back in there? And yes, of course, it's an anthropocentric viewpoint. I buy it. But I think within the tools that we have, this is, to me, one of the most promising ways forward. Now, it is a much more intrinsic worldview, rights of nature, than anything else we've had before, because we're really saying nature has its own inherent worth. And this comes from the indigenous philosophies, which I think is a fantastic, opportunity for indigenous people to lead the way and say, look, we've known this for all this time. Now, finally, we can actually bring it into the way we as a society function. Now, how that is going to be implemented, that depends on the people, the way the legal system works. And that's not something we can predict, but it gives us at least a chance. And I have seen a paper recently that showed that in Ecuador, which was the first country to enshrine rights of nature in its constitution, what they've seen is that very slowly, as lawyers and judges are becoming more familiar with the concept, they're better to interpret it when there is a legal case being brought. And they're better able to side on the side of nature. Now, that's a very slow process. And I'm not saying it's the panacea, but it's certainly much, much more positive than what we've seen in the past. So to those people who are critics, I'm sure I don't think, like I said, I don't think rights of nature by itself will solve all our problems. I think we could be open for many different approaches. It's just one of the options that we have. That's how I see it.
So I'm probably I am in a different camp to you. Would like to see a world in which we didn't focus on economic growth as a measure of success. And I would like to see a world where monetary value wasn't placed on everything. And I would love to see the end of capitalism in my lifetime. And yet what I think is something that is quite easy to forget for us Homo sapiens who have brains that are not trained in understanding complexity is that everything that we do has a knock-on effect, and not just knock-on in a linear thing. It's not just a set of dominoes, but it ripples out across the ecosystem. And changing this, with regards to our laws, changing the legal system ripples out so fast, essentially, amongst the rest of our social networks, and allows for decisions or imaginations or other possibilities that wouldn't have been possible without taking that initial step to then become clear and available to us. And I think that's what's particularly exciting about this, is it really does challenge the fabric or the foundations of how we define relationships, which I think is what a lot of these critics are saying, that we need to come back into relationship with the earth, and a mutually beneficial one, and one that does not place a kind of like anthropocentric hierarchy on that. And thus the idea of granting property, continuing the system of property, is dangerous. And I understand that, but also changing our relationship through law will allow for other possibilities of those relationships to emerge. And relationships are never static. They are always in a sort of dynamic movement with one another. And thus, even though this is kind of using a master's tool to maybe remodel the master's house, I think that doing it legally as opposed to economically could possibly have a bigger impact in a shorter amount of time, especially with the poetry of law. And just as you said, with like judges and lawyers now interpreting these rights differently, I think that's stunning. And I think that verb, interpret, really reveals the weight and the possibility behind the system.
Yeah, and if you look at, for example, Te Urewera, which used to be a national forest, and the Tuhoi Iwi fought for Te Urewera to become its own legal person. And once it was implemented, the trust board, the Tuhoi board, very clearly said, we are going to govern this according to our principles, our beliefs. So even though it's nestled in a standard legal system, it allows indigenous peoples to actually apply some of their tikanga in New Zealand and Maori. This means some of the way they do things, right? Their beliefs, their customs. So I don't think it's all black and white, right? There's got some room. And like I said, the devil lies in the detail. How exactly is this law implemented? How is it designed? Does it allow for some freedom of action of the advocates? And it's not just indigenous people, it's also local communities. For example, the most recent rights of nature was the Mar Menor Lagoon in Spain. And that has been really, it's been heavily criticized on all sides, saying, well, it's not enough, but, it's the legislation is not clear enough. But nevertheless, it's been really a grassroots sort of movement, and because of the despair that the community has been feeling through all the, pollution and tourism and all the detrimental impacts on the lagoon. How that is going to play out in the future, I don't know. No one knows it, but it is a start, right? It's something. It's a starting point, and we have to start somewhere. So that's how I see it.
I agree. Well, listen, Viktoria, with your continuing research, if you do manage to come across an answer soon about whether or not these legal tools can stem biodiversity loss, please reach out and we will do an update. And thank you very much for your time today.
Thank you for having me.
So this is like a really complex situation. And the gist that I got from the conversation with Viktoria, with you, is that it is really context dependent. So before we talk about some of the criticisms, what were your initial thoughts, your reaction to this conversation?
Oh, my reaction to the conversation was that it was a really helpful introduction to some of the differences of the legal frameworks that are on offer around the world, and also a very accurate analysis of the fact that this is one tool amongst many that can be deployed as part of a network or a system in order to try and shift our relationship towards the planet, i.e. the resources that we use. So I thought it was really interesting. And I think it's really interesting as well that Viktoria and her co-researchers decided to actually look at whether or not this stems biodiversity loss, because it's true that things can look really, really good on the surface, or they can be a kind of shining PR spin, or they can intuitively make sense, but that doesn't mean that the data always lines up. And so as I invited her, on at the end, I really, really do hope that once they get some firm data on this, they'll come back on the show and present it to us so we can really see what the impact of these schemes are.
Right. Yeah. The thing I got from this was that there is a lot of complexity in the iterations of these kinds of legal frameworks. And I thought that the examples that were brought up, such as the from my home state, Ohio, the Lake Erie example, where in literally just 1 year, that law got struck down by a federal judge, sort of highlighting the vulnerability of the law, the flaws within that approach in that specific instance. There was another criticism to this that was penned by some folks at the Community Environmental Legal Defense Fund that I just wanted to bring up with you. So I went through and I read this critique, and it sounds like they took an interpretation of what Viktoria was saying, criticized it, and they offered an alternative. They said, actually, Ecuador has a better answer to this question. But curiously enough, that was one of the examples that Viktoria mentioned in your conversation as being like a really effective way to do this, which was essentially to declare all of nature in Ecuador as an entity for which any person could stand up for, versus granting legal personhood to like a river or a specific ecosystem. And so it seemed like to me, we're getting some debate here, but we're actually more on the same page than maybe we realize, at least Viktoria and some other critics of this conversation.
Yes, I think that the enshrining the rights of nature in a constitution is exactly as you're saying, it's the big iteration, the big possibility. And I also really appreciate about that particular solution the fact that, as you're saying, it makes every citizen responsible, because obviously one concern with this would that it would be people who live in rural areas near a place that would be granted legal personhood that are then forced to also shoulder the entire burden or responsibility for looking after those ecosystem services, which would likely fall on indigenous groups, rather than kind of bringing everybody into that same new relationship of we all have to protect the nature that's around us all the time.
Right.
So I agree with you that I think for a lot of the criticisms, it was just that, this legal personhood isn't going far enough. Like, it cannot just be the first and last step. But I want to read out, if I may,
Sure.
a comment from law professor Anna Greer, who argued that the law needs to, quote, develop a new framework in which the human is entangled and thrown in the midst of a lively materiality.
Mm-hmm.
Do you know what that means?
I can't describe it, but I would like you to explain more to me. Yeah.
Well, I mean, I can't explain more, but I could riff more, because that was the end of her argument. But I think that, I mean, number one, it sounds like very Heideggerian, like very, very philosophical, this argument of like a human being as a being who is in relationship with the world, like being thrown with the world. And I get it. And it sounds, how do I put this? That sounds great. That sounds exactly like the kind of world that we would want. But also, having spoken with Viktoria, I can also see the flaws in that it's not something that's precise enough. And because it's not precise enough, because it speaks to more this like romantic vision of how we would like the law to support us and the world and our relationship with the world, then it might not be the kind of legal terms that can actually stem biodiversity loss or protect ecosystems. And so I think that for some of the critics who are saying it's not going far enough, as I sort of said in the episode, I mean, we all agree, right? And Viktoria agrees. It's the idea isn't that the buck stops there, but that these are the first necessary steps that you need to take in order to eventually get to a kind of law that sounds like poetry, which is what that quote from Anna does.
Right. Yeah. No, I got that too. I do want to play a quote from Viktoria that she said.
Now, how that is going to be implemented, that depends on the people, the way the legal system works. And that's not something we can predict, but it gives us at least a chance. And I have seen a paper recently that showed that in Ecuador, which was the first country to enshrine rights of nature in its constitution, what they've seen is that very slowly, as lawyers and judges are becoming more familiar with the concept, they're better to interpret it when there is a legal case being brought. And they're better able to side on the side of nature. Now, that's a very slow process. And I'm not saying it's the panacea, but it's certainly much more positive than what we've seen in the past.
That was the most interesting part, I think, for me. That little snippet. I'm so glad you've pulled it out again because, sort of alarm bells went off in my head when she said it, as if, I wish I could bookmark that part of the episode. Because it's one of the most fascinating things about law. Not just that legal cultures are built on precedents, but also they are built on interpretation, kind of like poetry. And so the more that the kind of legal class is getting to spend time marinating in this new constitution, the more that they are able to then understand as well, what would it be to speak on behalf of nature? What would it be to protect nature? What would it be for nature to have rights? And so this idea that, whatever decisions were being taken in 2009 in Ecuador, after that constitution was rewritten versus now in 2024, the possibilities that will have emerged just from having spent time with that law and decisions and dialogues being made with one another with regards to it will be totally different. So who knows actually where it could end up? And I think that's what's so exciting about enshrining the rights of nature in a constitution or using these big legal heavyweight verses.
Yeah, it's complicated. I left the conversation feeling much the same way as you did about it. And it's just something that continually looks like it's going to need to be discussed, debated, things tried. Like it's always going to be a evolving thing. There's clearly no one silver bullet solution per se.
But just think about it. For example, say, let's pick modern medicine as an example, right? Say that there is an ingredient that is really, really necessary to a pharmaceutical branch. I don't know. I don't know what is the medicine that we need most of. I don't know how we make any of our medicines. But just say there's something that we need in a biodiverse hotspot, for example, and say that this is a world in which we've enshrined the rights of nature. What happens to those tensions when it's like, okay, well, this forest has its own rights protected. We are not allowed to just go in and take what we want. But by the same token, there's, 8 billion, maybe 9 billion people in this, imagined future that need modern medicine in order to survive and live good lives. What do you do in those scenarios? That's when you play it out, there does come a point of decisions will have to be, and maybe it's the decisions will have to be made holistically. Maybe it will be more, because we're taking a little bit from there and we have to, then we're going to protect a little bit more over there. But then that starts to sound a bit like biodiversity credits. And, there are points in your thinking where you're like, the human impact on the planet, there is no, exactly what you're saying. There is no one way or one silver bullet to manage that. It's going to have to be consciously, constantly managed.
It's exactly the kind of conversations we're going to have when, like you just met. It's a great question. It's a great scenario because, frankly, I don't know. I don't know what happens. It's so context dependent. I don't know I just don't know. This is a great question, though.
Yeah, tune in next week. Maybe we'll know then. I think definitely one to watch. This is something I'd like for us to keep digging into on the show. How the law responds to a changing world when the law was not built to protect everybody, but built to protect a small people. I think it's a fascinating point in history, and I'm interested to see if it will be able to bend and evolve, or if it will kind of shatter under the tension.
Yeah, I am likewise extremely interested to see how this goes. To read more about legal personhood, rights of nature, or to view the articles referenced in this episode, you can find links in the description. As always, if you're enjoying the Mongabay Newscast or any of our podcast content, such as our sister series Mongabay Explores, and you want to help us out, we do encourage you to tell people about the work we're doing. Word of mouth is definitely the best way to help expand our reach. And you can also support us by becoming a monthly sponsor on our Patreon page at patreon.com/Mongabay. We are a nonprofit news outlet, so that means just $1 per month really makes a difference and it helps us offset production costs. So if you like what we're doing and you enjoy our audio reports from Nature's Frontline, go to patreon.com/Mongabay to learn more and support the Mongabay Newscast and all the podcast content that we produce. You and your friends can join the listeners who have downloaded the Mongabay Newscast over 500,000 times by subscribing to this podcast wherever you get your podcasts from. Or you can download our app for Apple and Android devices. Just search either App Store for the Mongabay Newscast app to gain fingertip access to new shows and all of our previous episodes. And you can also read our news and inspiration from Nature's Frontline at mongabay.com, or you can follow us on social media. Find Mongabay on all our social media accounts on LinkedIn at Mongabay News, and on Instagram, Threads, Blue Sky, Mastodon, Facebook, and TikTok, where our handle is at Mongabay, or on YouTube at Mongabay TV. Thank you, as always, for listening.